147th meeting of the Tennessee Advisory Commission on Intergovernmental Relations to order. And the first order of business is minutes of the September meeting. You have received those previously, and I will entertain a motion to approve those minutes as presented. We have a motion. Do we have a second? We have a second. Do we have any discussion, additions, or corrections to the minutes? Okay, hearing none, all in favor of approval of the minutes, please indicate so by saying aye. Aye. All opposed likewise. Minutes are approved. Next, we have commission and staff update.
Thank you, Mr. Chairman. So, as I know everyone else has heard now, we of course learned with great sadness about the passing of Chairman Charles Sargent back on November 13th of this year. Chairman Sargent was, of course, a member of the commission for 8 years and, of course, served 22 years in the legislature from the 100th through the 110th General Assembly. At this time, I'd like to ask Research Manager Mark McAdoo is going to read the resolution honoring the service of Chairman Sargent, and that's found at the back of tab 2.
Thank you, Mr. Chairman. Members, I'm Mark McAdoo, Research Manager for TACIR. It is a privilege to present the resolution to honor the memory of Representative Charles Sargent of Franklin, Tennessee for his meritorious service on the Tennessee Advisory Commission on Intergovernmental Relations. Whereas it is appropriate to honor members upon completion of their terms who have performed their duties with the utmost integrity and whose efforts have ensured proper attention to innumerable issues in fulfillment of the Commission's mission to serve as a forum for the discussion and resolution of intergovernmental problems, to provide high-quality research support to state and local governments in order to improve the overall quality of government in Tennessee and to improve the effectiveness of the intergovernmental system to better serve the citizens of Tennessee. Whereas Representative Sargent, a native of New York and an alumnus of Pace University, served in the United States Navy from 1965 to 1967 before moving to Tennessee in 1970 and establishing a successful insurance business. Whereas Representative Sargent, with his wife Nancy, raised 3 wonderful children, Margaret, David, and Sean. Whereas Representative Sargent served his community, notably helping Columbia State Community College find funding for its Franklin campus expansion, co-founding the Grassland Athletic Association, serving as president of the Grassland Parents Association, serving as honorary trustee of Columbia State Community College, serving as a member of the Williamson County Medical Foundation Board of Trustees, serving on the Williamson County Planning Commission, and serving as a county commissioner for Williamson County. Whereas Representative Sargent served his community as a member of the House of Representatives from the 100th through the 110th General Assemblies. Whereas Representative Sargent provided leadership in the legislative process during his time in the General Assembly as chair of the House Finance, Ways and Means Committee, and as a member of the House Calendar and Rules Committee, the House Insurance and Banking Committee, the House Rules Committee, the House Commerce Committee, the House State and Local Government Committee, the House Government Operations Committee, the House Ethics Committee, the House Finance, Ways and Means Subcommittee, the House Finance, Ways and Means Study Subcommittee, the House Small Business Subcommittee, the House Industrial Impact Subcommittee, and the House General Subcommittee of Commerce. Whereas Representative Sargent served with distinction as a member of the Joint Fiscal Review Committee, the Joint Committee on Pensions and Insurance, the Joint Workers' Compensation Committee, the Joint Legislative Management Committee, the Joint Lottery Oversight Committee, and the Joint Business Tax Committee. Whereas Representative Sargent served as Republican Caucus Chairman of the 103rd General Assembly and Minority Whip of the 101st and 102nd General Assemblies. Whereas, in addition to the aforementioned leadership roles in public service, Representative Sargent received many awards, including the 2018 Business Legacy Award, the 2016 Tennessee Court Appointed Special Advocates President's Award, the 2015 Disability Hero Award, and the Tennessee Disability Coalition, the 2014 Legislator of the Year honor by Tennessee Men's Health Network, the 2014 Champion of Commerce Award from the Tennessee Chamber of Commerce, the 2014 Legislator of the Year honor from the National Association of Mutual Insurance Companies, the 2013 Traffic Safety Champion Award from the American Automobile Association, the 2013 Community Action Partnership Award from the Tennessee Association of Community Action, the 2002 and 2003 Legislator of the Year honor from the Tennessee Development District Association, and the 2001 Outstanding Representative accolade from the County Officials Association of Tennessee. Whereas, in addition to his many leadership roles, Representative Sargent served with distinction on the Tennessee Advisory Commission on Intergovernmental Relations from January 2011 through November 2018, helping provide leadership and direction to the Commission staff. Now, therefore, be it resolved by the Tennessee Advisory Commission on Intergovernmental Relations that we hereby honor the memory of Representative Charles Sargent, reflecting on his valuable contributions to the Tennessee Advisory Commission on Intergovernmental Relations and for his honorable and dedicated service to the good people of Williamson County and this great state. Be it further resolved that we express our sympathy and offer our most heartfelt condolences to the family of Representative Charles Sargent. Thank you.
Okay, you have heard the reading of the resolution, and we have similar resolutions that are in your packet, one for Representative Wergo, one for Senator Harper, and one for Commissioner Crossley. So I will entertain a motion to approve all of those resolutions. We have a motion. Do we have a second? We have a second. Now, do we have any discussion of those resolutions? And I would say of two folks on there, Representative Sargent and Representative Wergo, we lost a great deal of experience in, not only experience in knowing about local government, but supporting local government and being an advocate for local government in those two individuals in the legislature. And we're certainly going to miss all of them, but in particular Representative Sargent and Representative Wergo. Do we have any discussion or comment on the resolutions as presented? I am not presenting now Judge Norris's resolution because he intends to be here at the next meeting to accept his resolution. So hopefully he can do that and we can vote on that at that time. Do we have any further discussion concerning any of these resolutions?
I'd just like to thank them all for their service and the contributions that they've made during that time of service.
Good. Any other comments or discussion? Okay, hearing none, all in favor of approval of these four resolutions, please indicate so by saying aye. Aye. All opposed likewise. I declare the resolutions approved unanimously. Okay, continue.
So it's not all goodbyes. We do have some new members that we'd like to welcome also, and this is also noted on page 2 of tab 2. We'd like to welcome two new members. Mayor Kevin Brooks of Cleveland, Tennessee was appointed on November 6, 2018 by Governor Haslam to serve on the commission. Welcome, Mayor. And Mayors Rogers Anderson of Williamson County was appointed on December 5th, 2018 by Speaker of the House Harwell. Welcome, Mayor. And last but not least, of course, we are happy to announce that longtime member County Executive Jeff Huffman has been reappointed to the commission. So congratulations. And we, in staff updates, we presented two recognitions of longevity of service before the meeting. We've already taken the pictures and everything, but would like to at this time have Research Manager Mark McAdoo stand again. Mark has achieved 25 years of service to the state of Tennessee. Fantastic job, Mark. And also Senior Research Associate Nathan Shaver. Nathan, it took him two tries at TACIR, but he's now achieved 5 years of service. He left for a little while, but he came back. They always come back. Congratulations, Nathan. And then finally, Senior Research Associate Dave Kaiser, who is at a meeting right now and isn't here today, I don't think. He graduated from the Lead Tennessee program on December 10th. He's the 6th member of our staff to graduate from this comprehensive leadership course for state employees. So if you could all join me in just congratulating all three of these TACIRites on their service. Thank you. Mr. Chairman.
I'll just note welcome to the new members, and just a note here, Mayor Anderson, who lives closer than anybody, was late today, so I just thought I'd bring that up. Okay, we will now move on to tab 3, which is House Bill 971, Senate Bill 1075, concerning local revenue and services, and I will introduce our Senior Research Associate, Michael Mount, and he's going to introduce our panel today.
Thank you, Chairman. Commissioners, I'm Michael Mount. At its September 2018 meeting, the full commission agreed with the recommendation from the working group of its local government members that the commission's study of revenue and services of local governments in Tennessee should initially focus on the internet and streamlined sales tax issues. The commission also agreed that representation from the Department of Revenue should be included. And so with that, I'll introduce our panel. David Jargano, Commissioner of the Department of Revenue. Donald Bruce, Professor, Boyd Center for Business and Economic Research and the Department of Economics at the University of Tennessee, Knoxville. And finally, Scott Peterson, who is Vice President of U.S. Tax Policy and Government Relations at Avalara, and he was also the Executive Director of the Streamlined Sales Tax Governing Board until 2012. So with that, our panel.
Let me say a special welcome to each of you. We appreciate you all being here today to discuss this very important topic to all of us, and appears like we have a lot of expertise in the panel today, and again, thank you for being here.
Thank you, Mr. Chairman. I guess I could start. David Jargano with the Department of Revenue. Very pleased to be here with you. Appreciate being invited. We've had a number of conversations with the TACIR staff and various members of TACIR about this issue over the last several months, and have enjoyed very much those meetings. I would like to be a resource today, help answer any questions that you have about the Department's administration of sales tax, and particularly around the online sales tax issue. To give maybe just a brief update or introduction, as I think you all know, this has been a long road for the states in addressing the online sales tax issue and the physical presence rule, culminating in the recent U.S. Supreme Court decision, Wayfair versus South Dakota. And as part of that journey, in 2016, the department promulgated a rule which stated that taxpayers with more than $500,000 in sales to Tennessee residents would begin to be required to register and collect sales tax, that being, of course, state sales tax, and more on point with this meeting, local sales tax. And that was done with everybody's understanding that it was to generate a case to try to get back to the U.S. Supreme Court to have them re-examine the physical presence rule that they had laid down in the Quill decision in 1992. Other states were a part of that effort as well. It was really precipitated by Justice Kennedy of the U.S. Supreme Court, essentially inviting states to bring a case back for the court to re-examine that issue. And so states participated in trying to get a case back in front of the Supreme Court. It turned out South Dakota was the case that got there first and resulted in the Wayfair decision. So we still have that rule. That rule was promulgated when it went in front of the General Assembly as part of the Omnibus Rules bill. It was made permanent, but as part of that public chapter, the General Assembly said that the department, if and when the rule was upheld by the court, and it turned out it was, that the department would not enforce that rule until it was reviewed, the rule and the decision were reviewed by the General Assembly. So that's really the posture we're in right now. We have a rule that was promulgated, became permanent, but enforcement of that rule is on hold until it's subsequently reviewed by the General Assembly. There was a court case. I can let the commission know that court case has subsequently been dismissed. A Tennessee-specific case challenging our rule was pending in Davidson County Chancery Court when Wayfair came down. That case has now been dismissed. You know, I know the commission has been interested in the distribution of local sales tax collected from out-of-state vendors. I would be happy to go into that in whatever detail you desire, maybe leave that for answering questions. And, you know, we're continuing to monitor what other states are doing around this issue. And I know Scott is an expert and will probably go into that in more detail, but I will just mention, we count about 30 states that have issued guidance to taxpayers that would file sales tax returns in their state. Really, a lot of the discussion around that is what is the threshold? We put in our rule a $500,000 threshold, meaning if you have more than $500,000 in sales to Tennessee residents, then you're subject to the rule. South Dakota adopted a threshold of $100,000 in sales or 200 transactions, either of those triggering the requirement to collect. And because that case is the one that went in front of the Supreme Court, a lot of other states have adopted that same threshold level. So we count about 19 states that have issued guidance with a threshold of $100,000 or 200 transactions. There are about 3 other states that are at the $500,000 threshold that we're at. The remaining ones are there are a handful at $250,000 and a few at $10,000. So we're continuing to watch that issue as well. And again, I would be happy to answer any questions at whatever point in the meeting. Thanks.
Good afternoon. Is this on? Okay, here we go. Thanks. Don Bruce, University of Tennessee. It's a real pleasure to be here. We've been thinking about this issue in the Boyd Center since before the internet. That certainly predates my time in Tennessee, but about 5 minutes after I arrived at the university in 1999, Bill Fox wandered into my office and said, "How would you like to think about this internet sales tax issue?" And he and I spent the better part of a year estimating revenue losses to state and local governments, and we've updated those numbers. And I appreciate that this commission has given me the opportunity to finally meet in person Scott Peterson, who we worked very closely with for the better part of 10 years on this issue. So it's been a great couple of decades working on this in Knoxville. I feel like this issue is extremely important to the state of Tennessee. It's extremely important to local governments in Tennessee, and we need to get it right. There's a lot at stake. Bill and I, and later with Leanne Luna, we've always said this is not a revenue issue, and we would certainly hope that the policy conversations moving forward are not focused on revenue. To the extent that this new world order after Wayfair provides new revenue for state and local governments, fantastic. We estimated losses. We think there will be revenue gains, but that should not drive the policy conversation going forward. To be sure, a very large number of multi-state online retailers are already collecting and remitting. We've been enjoying those collections for several years now in Tennessee. And also, to be sure, when you really sit down and think about the thresholds that Commissioner Giorgano has just mentioned, that are actively being discussed in states around the country, there are very few companies in a global sense, in a national sense, that would be above those thresholds and would be universally required to collect and remit. So let's be very cautious about focusing on revenues and really sit back and think, if I may impart the academics focus on this, that would be, how can we do this the right way? The issue's always been about tax fairness for us. We think the similar transactions ought to be treated similarly for tax purposes. That focus should not change now. The focus needs to be on tax fairness as it relates to the locations of the impacts of the losses that have been going on for decades, and thinking about how we might capitalize on this new world order to right some of those wrongs. Wayfair does, in fact, give us everything we've always wanted. At the same time, it gives us an absolutely horrible set of policy challenges, if you will. So getting this right is not trivial, and there are lots of ways to get it somewhat right. And there will be winners and there will be losers, or there will be winners and there will be lower degree winners. And that's okay. Let's recognize that this outcome, regardless of where we land, is better than 1999 when I first got to Knoxville and we couldn't enforce tax fairness on remote sales at all. So in this policy environment where states are obviously self-interested, they're trying to work on policy reform internally that protects their own menu of public services and also protects the state and local governments within their borders, some degree of collaboration would be in order and would certainly be well advised, as we'll hear from Scott, to think about what other states are doing and also pay very close attention to what policy changes may come down from the federal level as well. The things that that I hear from the federal level at this point are mostly, this is it, Wayfair is here, we're going to live with it, rather than some of the early fears about what can we do quickly to unwind this and legislate a physical presence definition of nexus. I think we've got some pretty serious action from states without sales taxes to try to protect their businesses from efforts from states like ours to enforce collection of sales taxes on sales into Tennessee, for example. They're obviously interested in protecting their own enterprises. But some of the things involved with that legislation, for example, the most recent legislation would delay collections until 2020 and create a national $10 million small seller exemption and require states to join a compact like the Streamlined Sales and Use Tax Act in order to collect online sales taxes. Obviously, from our perspective, this would be a misguided set of policies to apply to all states in the country. So we would certainly encourage more deliberate policy action driven by state-specific revenue authorities going forward. One of the more interesting pieces of this as we go forward is the extent to which you can do the distribution of the local option sales taxes the right way. And it's important to keep in mind that we don't redistribute now currently, and we didn't before the internet. I live in Walland. I do most of my retail sales transactions in the cities of Maryville and Alcoa, maybe Louisville, Mayor Bickers, and certainly in the city of Knoxville. And none of those tax dollars necessarily get sent back to Walland or to Blount County. And so the idea that my online sales taxes, when they are sent to Tennessee, should go to Walland or Blount County, in theory makes a lot of sense. In practice, we have to be very careful about being consistent with what we're trying to do and the extent to which we're creating more difficult administration on the online piece than we do in the in-person piece. But none of these problems are without solution. We look forward to playing a role to the extent that we possibly can from the research center at UT, and look forward to the conversation today as well.
Thank you all very much for the invitation. I too am glad to have this so I can get to meet Don. I think our first telephone conversation would have been about 2004, somewhere in there. I come to this current position by accident. But I spent the first 12 years of my life working with the South Dakota legislature, and I was their tax and local government specialist. So I wrote all the tax legislation, all the local government legislation, did all their research, staffed all the committees. Went from there to be the director of sales tax for the state of South Dakota. So for 10 years, I was the person responsible for making sure that the sales tax operated, and I was the chief policy officer for 2 different governors. And in that, we created the Streamlined Sales Tax with Tennessee and a bunch of other states. And in the Streamlined Sales Tax, there's this obvious question. Well, how much money is there? How much money are states losing? The business community at that time was taking the position that there was very little. And if there was money lost, it was the state's fault. It wasn't the business community's fault. So we hired our friends from the University of Tennessee to do this study because they had already started the work and they were doing some of this for the legislature already. Great study. I loved it. I defended that study, and I still defend the quality of that study. And I have to do so often because there's still people that think it isn't very good, and I tell them they're all wet. But the issue, as Don said, isn't about this being a revenue issue. If it is a revenue issue, this is the negative revenue issue, because every day that goes by where someone isn't collecting the Tennessee sales tax, there's some consumer that's not paying the Tennessee use tax. So all of us as consumers are the reason why this is a revenue issue, not because the businesses haven't been collecting, because you have a law that makes this the law. After a few years on this representing South Dakota in Streamlined Sales Tax, they asked me to be their first executive director. At the same time, I married a commissioner of revenue from Tennessee, and I moved SST to Nashville. Did that for 7 years in an office in Green Hills. And then the folks from Avalara called me up. Avalara is the country's leading provider of sales tax compliance software to retailers in this country. Our focus is to eliminate the burden the state and local governments impose upon retailers to collect sales tax around the country. Of course, we also do that in Europe on the value-added tax. We do it for motor fuel taxes. We do it for lodging taxes. We do it in the goods and services tax in Brazil. We do it in the goods and services tax in India. And we do the whatever the heck they have in Canada. They have both in Canada. And so my job today is to help the leadership of Avalara understand the tax framework that exists in every city, in every county, in every state in this country, so that we can build software and processes to help retailers deal with whatever's coming down the pike. Our rule is if the answer to your tax policy is either yes or no, you can put it into a computer. If the answer to your tax policy is, well, anytime someone starts a conversation trying to explain tax policy with the word well, you can't put that into a computer because that does not lead to a yes or no. So that's me, and I've been doing this for 6 years now, and I travel around the country talking to people about Wayfair these days. Mostly because I spent 10 years working with the South Dakota sales tax system, and everybody assumes, since it's South Dakota versus Wayfair, that I know something about South Dakota, and it's true, but I have to know a lot more about everybody else than just South Dakota. David's right. According to our map, we have 29 states that have issued some sort of guidance. This guidance comes in the form of legislation, comes in the form of regulation, and in some places it just comes in the form of, we're going to start enforcing Wayfair. Wisconsin is an example of that. They said, we think our law has always said retailers have to collect our sales tax. It's only because the Supreme Court wouldn't let us that we weren't able to enforce it. But now that that's gone, we're going to start enforcing it. Ideally, a statute is the preferred way that the business community would like to see states do this. Regulations aren't bad because you can actually, there's a hearing, you can go in and talk to people about a regulation. It's hard to talk to departments of revenue about a policy that they're going to change. Of those 29, almost everyone is exactly alike. That's the good news. They all use either sales or a transaction, sometimes both. Sometimes not. South Carolina is just all sales. It doesn't make any difference, frankly. I don't think. I'm spending a lot of time in the last month looking at our customers' data to try to figure out if there is a rational thing to use as the trigger. Should it be dollars or should it be transactions? Should it be a combination of both? It should be neither. And so far, based upon our customers, I haven't figured out a pattern yet that really works. There's some really odd things that come with using transactions. There are folks that sell lots of little stuff, lots of stuff. And they go over 200 transactions within a month in almost every state in the country, and often haven't sold more than $600 worth of stuff in that state. And they'll go the whole year. I mean, we've got customers that in the entire United States will make 150,000 transactions and won't have more than $300,000 in receipts, $400,000 in receipts. Just really small businesses. They sell little tiny things. There's a couple, there's a Bible company that fits that category. I'm thinking, well, how in the world? What? I mean, I paid more than that for a Bible. How's this? What are you charging me these things? So I don't know what the answer is on dollars or threshold or transactions. There doesn't seem to be a right answer. Connecticut has done both. So in Connecticut, it's $200,000 and 200 transactions. That's probably a more rational way of doing things, other than to do what South Carolina did, would just do dollars. But neither of those, or what everybody else is doing, gets you a normal retailer. You look at the people that are in this, that are caught up in these by these thresholds, you can't identify a normal retailer. There is no pattern there. 21 of these laws are in effect today. We're going to have 6 more going into effect on February 1. Wyoming, as they've announced, their law will go into effect on February 1. 16 of the states so far use gross receipts or gross sales as the trigger for determining whether or not you've exceeded the threshold. At some point in time, that has got to change. So I do webinars and presentations all the time. I did 2 yesterday. I'm doing 1 tomorrow. And the number one question I get asked by people is, do I have to include my exempt sales when I'm determining whether or not I have to collect sales tax? And like I said, the law in 16 states is yes. And I will be talking to someone who operates a business that only sells for resale. They have no taxable transactions anywhere. But in 16 states, they're going to exceed the threshold. They're going to have to get a sales tax license, and they're going to have to file at least 1 return a year telling the state, yes, we sold $500,000 in your state, all for resale. We owe you no tax. They use us, so I'm going to charge them $25 for that, because that's about the least that we charge anybody is for a return is $25. So they're going to pay $25 to us to file that return. They're going to have their CPA do it. The CPA is going to charge them $75. And there will be nothing the state gets out of this other than knowing that there's somebody who's making sales into the state for resale to somebody else. Maybe it has value to the Department of Revenue. Maybe it doesn't. Someday you will have to back up, evaluate the type of returns you're getting, the type of people you're interacting with, and change that. Because you're creating work for people when the only thing you're going to get from it is heartache. Because a lot of these people live in Tennessee. They live everywhere. And I want to talk about that in a second, but remember, you're not talking about Chicago retailers. You're talking about Louisville retailers. You're talking about people who've decided the best way for me to compete in this world is to sell online or to sell on a catalog. And so every time you are exposing someone from Chicago or New York City or New Hampshire to the laws of Tennessee, they're doing the same thing to your neighbors and family. Let's see. The big states haven't jumped in yet, other than Illinois. Illinois is a really big state that's jumped in, and they did exactly what South Dakota did. Texas is having conversations. Their conversations are about having a uniform rate. They have 1,750 local taxing jurisdictions in Texas. It's a big state. They use origin sourcing. Worst invention of all time when it comes to sales tax, origin sourcing. And they do it in a really bizarre way. It's very complicated to collect a sales tax in Texas. So what they want to do is do a one rate, a weighted average rate that would apply to any remote seller. Anybody that does not have physical presence would collect one rate in Texas, and then Texas would divide that money amongst all the local governments according to some formula. Very simple, very straightforward, helps the people that have absolutely no physical connection to Texas at all, does nothing for the people inside of Texas. California is doing something completely different. Their proposal so far is to take the 100,000 in sales over 200 transactions like South Dakota has and apply them to the state and then apply them to every local government in California. So you sell $101,000 into California, so you meet their economic nexus threshold, you have to collect the state sales tax. Then it would be then you would collect local city taxes after that based upon whether or not you exceeded $100,000 in sales into that city. So you're a Louisville retailer and you're trying to manage your sales tax compliance in California because you've exceeded $100,000 there, so you have no choice. And then you have to start keeping track of every city inside of California where you make sales and then project where you're going to exceed that threshold in which cities and at what time so that you know when to start collecting sales tax in that city in California. Crazy idea, absolutely crazy. The most complicated state in the country is Colorado, and they're complicated for a dozen different reasons. First and foremost, they're complicated because they have 72 cities and counties that do their own administration. So you've got the state Department of Revenue, which administers the state's sales tax, plus the sales tax for 230 cities, counties, and special taxing jurisdictions. And then there's 72 that do it all by themselves. So there's 73 Department of Revenue in the state of Colorado. Every one of those 72 has their own tax commissioner. They have their own sales tax return. They have their own list of things that they tax and exempt. They have their own rate. They have their own exemption certificate. They have their own auditors. So the state is trying to do something for itself and the 230 it administers for so that they can capture the sales tax from Louisville merchants that are selling into Colorado. The 72 home rule cities and counties haven't made a decision yet what they're going to do. And every lawyer I know in the United States is telling their clients, don't collect for anybody in Colorado except the state, because that's the only thing that they can actually enforce on. Alabama's done a single rate. There's lots of complaints from the local governments about the single rate, but that's, I think they're managing that. Louisiana, 70, 68, 69, 70 parishes down in Louisiana, and a parish is a county. Plus they have a bunch of cities inside those parishes that have sales taxes. The legislature passed a commission, the Remote Sales Tax Commission. So they transferred the authority for the administration of the sales tax on remote sellers from parishes and from the state to this commission. And the commission is exercising its authority, if one can actually give authority to a commission to do this, that makes them responsible for helping out-of-state retailers collect. The original plan was they were going to build a software system that would do this, and that if you just created the software system, the retailers would be able to collect the state and parish tax in Louisiana. And I convinced them that that was crazy because no one would ever use it. No one can use a software system that only works for one state. You got to have a software system that works for every state. And then they were going to go to one return that every out-of-state retailer would use, and then that all fell apart, and they're back to bickering. Alaska doesn't have a sales tax, but there's about 150 cities and towns in Alaska that have a sales tax, and they want some of this money as well. And so they're trying to figure out how they can how the Alaska Municipal League can become a Department of Revenue for the cities and towns in Alaska. This is, as Don said, this is a big deal. States have been so 1982, I go to work for the South Dakota legislature. 1983, first legislative session. First person to walk into my office to ask me to draft a piece of legislation was the executive director of the South Dakota Retailers Association. 1983, he wanted a law that would make catalog companies collect sales tax in South Dakota. I've been doing this for a long time. And I, still today, I still don't believe that South Dakota won this case. And they didn't win. That's the irony. They didn't win. This court just said we were wrong before. They didn't say South Dakota won. They didn't say Wayfair lost. They just said we were wrong before, and we're not going to use physical presence anymore. There will be more lawsuits. There will be. There's a bunch of really enterprising law firms out there that used to make a lot of money on Quill and physical presence that don't make any money on that anymore. They're going to find a way to make money. Thank you.
Okay, thank you all. It might be good, Commissioner, if you'd give us a little explanation for those that don't understand how it's presently, how sales tax is presently distributed in Tennessee. That might help us a little bit if you would do that.
Yes, Mr. Chairman, be happy to do that. So, of course, we have a state sales tax and a local option sales tax. State sales tax being generally 7% on most items. State collects that money. It goes to education and to the general fund and to cities as state share tax. I think you're more interested in the local sales tax distribution. And of course, local sales tax can be up to 2 3/4%. And when an out-of-state dealer who has no locations in Tennessee makes sales and collects that local sales tax, they have an option. They have two choices. They can collect the specific rate that that particular jurisdiction to which where their customer lives. They can collect the specific rate for that city or county where their customer resides, report that to the Department of Revenue, and that money will be distributed by the department directly to that jurisdiction. Alternatively, and this was put in the law in the late 80s to make it easier for out-of-state sellers to comply with the law, they can elect to use a uniform 2.25% local sales tax rate, regardless of where their customer lives. So all of their sales in Tennessee, they can apply that one rate, 2 1/4%. They do not then need, or would they, report to the Department of Revenue the specific location of their customers. They would just send us the proceeds, and the statute provides for a formula distribution of that portion. The formula distribution is essentially based on the relative in-state collections of the various jurisdictions. So initially, it's divided a portion among the 95 counties in relation to how much are their in-state collections. So if a particular county represents 2% of total in-state local sales tax collections, then 2% will be allocated to that county. So it's first divided among the 95 counties, and then within each county, it is distributed among the cities in that county and the county itself, again, based on relative in-state collections within that jurisdiction. So the foundation for the formula is how much of in-state over-the-counter collections occurs in a jurisdiction, and it's that proportion of this out-of-state money that goes to that jurisdiction. Historically, all of the out-of-state sellers were collecting the uniform rate, and it was all being distributed by the formula. That is changing as the landscape changes. More and more out-of-state sellers are foregoing the uniform rate and instead choosing to collect the specific local rate for the specific jurisdiction. I think that's because they're doing it in these other states, and so it makes sense to do it in Tennessee as well. By our last calculation, about 40% of the out-of-state tax revenue is being reported by the vendors and distributed to local governments based on the residence of the customer. The specific local rate being distributed to that specific jurisdiction. About 60% is still being distributed by the formula. But the 40% number is growing as sellers move more to that because they're having to do it in other states.
I have several questions, so Chairman, just stop me when you want me to quit. First of all, Commissioner, as I understand it, one of our issues for local governments will be the fact that the way the law is currently, or the rule is currently written, that the way things are done out of the state also have to be done the same way in the state, or something to that effect. Is that correct?
I anticipate you might be referring to the streamlined sales tax legislation and origin sourcing versus destination sourcing. That's not really an issue in the rule. It's an issue in sort of the way the law is developed around joining Streamline. If that's the issue, so the Streamlined agreement originally required destination-based sourcing for all sales, regardless of whether it's a sale coming from out of state or it's a purely in-state transaction. It had to be based on the destination. So what's different about that than our current law is if you think in terms of a retailer who makes deliveries, whether it's furniture, appliances, building materials, those sorts of things. If Tennessee law has always been that the tax, the rate and the revenue from that stays in the county where the retailer's located. So it's all based on where the store is. That generally referred to as origin-based sourcing, the origin of the sale. Under destination-based sourcing, the rate that you apply and the proceeds of the tax on that sale go to the jurisdiction where the customer is, where the delivery, the destination of the sale. That's not the law in Tennessee, but that is what the Streamline agreement originally required. So there is legislation that was passed originally back in 2003 that has always had a future effective date. And if you've been watching this issue, you know that we've pushed that out every 2 years for the last 10 years or more. And so that provision to change to destination sourcing is in that legislation that has that future effective date. The current effective date of that is July 1 of 2019. So it'll either go into effect or it'll be pushed out again. You know, it's something that'll have to be decided by the legislature. The thing that has changed in the meantime, and Scott would certainly be one who could address this, but the Streamlined Sales Tax Agreement has been modified in the intervening years. So destination sourcing for in-state sales is no longer a requirement of the agreement. Okay. So it's embedded in our law, but it could be changed and you could still be a member of Streamline.
Thank you. On Professor Bruce, on your comments, you emphasized something that I would expect from an academician, and that is we should exclude the idea of revenue in policy. Well, I have to chuckle. Everything's revenue driven. At the state level, I mean, only those of you in schools can talk like that. The rest of us have to pay bills. So for the local municipalities, for the county governments, for the state government, it's a matter of how do we pay the bills. And particularly in Tennessee, with only sales tax and property tax as revenues, it becomes even more of a concern for us. So I would just make that comment that I don't, and it was echoed somewhat by Mr. Peterson, but I don't think that it's possible to not consider revenue in this. Now, you talked about situs-based, and we had two or three lengthy discussions between the municipalities and the counties over this issue so that we could, and with the agreement we did come to was that it would be situs-based, and that way if it was purchased in the county, it would go to the county, and particularly if, I'm very heartened to hear that the agreement has taken out the in-state issue, because that was fearful for particularly the municipalities where most of those businesses lie. So if that's out of there, then the ability to do what we compromised on, I think exists better, and that is to pay to where the situs is. And if it's a person out on the farm in the rural area and unincorporated, then it goes to the county government. If it's somebody within the city of Bartlett or another municipality, it would go to that municipality because those are the people that are providing the services for that individual. And that's what the taxes are for. They're to provide services. And so it is a revenue issue to be able to provide these services, not only, and I guess I would just say this in regard to Mr. Peterson's comments about the burden of collection on the retailers. I understand that. I was involved in the 1980s, might have run into you in the halls, and we probably looked a whole lot different back then. But I was on the White House Conference of Small Business back in the early 80s and was on the other side of this issue. But that being said, I now know that the only way in Tennessee for us to be able to provide police and fire and building inspections and all of those things depends on the revenue we receive out of different areas and heavily for the municipalities on the collection of sales tax. So I just would like to know how, and I think you answered this, Commissioner, how the current revenues are divided. Now, if I understood you kind of answered it, and I'd written down as a question, so I was trying to listen very carefully, but I could have misunderstood. So currently about 40% or 60%, which one is getting the formula that actually looks at situs and the actual rate of that municipality or jurisdiction?
Yeah, for the out-of-state sales, about 40% is based on the actual jurisdictional rate and where the customer is located.
And you said that is on the uptick.
Yes, sir.
And so it's my suspicion, and you guys can tell me you think I'm right or I'm wrong. History will prove out, I guess, the answer to this. But it seems to me that that's going to depend on the most stringent states' rules. Because I think everybody, like you've done, Mr. Peterson, you've been working with retailers to provide them with the simplest transaction computer program available, and that's going to go to the most difficult so that they can do the most difficult work. And I think everybody will kind of trend to that so that it will kind of homogenize. Is that a fair statement?
I don't see much homogenation going on, but you are right. Our system has to deal with the most complicated thing there is in the world. Most states aren't moving toward complexity; they're moving away from it.
Right. Well, I think it's, when you get down to the lobbyists that visit with our good legislators here and share their concerns about their constituencies, it does come down to how does it impact businesses doing business in Tennessee? And secondly, the ability for our citizens to have a fair tax rate that actually pays for the services that they receive. And so that's the balance, which, again, all of that to me has to do with revenue. Maybe you can enlighten me some. I didn't go to the University of Tennessee. I went to Freed-Hardeman. We didn't get that deep into that stuff. So, did you have anything, Professor Bruce, on that?
Well, if I could go back and clarify a little bit on the revenue piece, I appreciate your point. From our perspective from the beginning, the internet sales tax problem needed a solution, not to raise additional revenues, but to create a more fair sales tax structure. That was the essence of that point. And as we move forward into thinking about some of these very real challenges, especially for the local governments, there are lots of possible solutions that raise revenues for all of you. Right. And the point is not to choose the one that maximizes the revenue. The point is to choose the one that gives us the most sustainable and, by as many measures as possible, the most fair structure going forward. And those are the kinds of problems that we love to think about. And Commissioner and I spoke a minute before this meeting began. I think I'm maybe in a better position to just theorize on some possibilities without fear of loss of employment for the next couple of minutes anyway. We'll see if I can get back to Knoxville before the news travels. But when you think about a formula for distributing this local sales tax revenue. Why does that revenue get distributed on the basis of existing in-state sales tax collections? That's not where the buyers are necessarily. It's not necessarily where the transactions would be cited under a destination basis system. Could we not think about a personal income basis for distributing those revenues? Could we not think about population more broadly? Could we not think about something else that's more tied to the location of the activity from the buyer's perspective in a way that doesn't perpetuate the concentrations of the sales tax revenues in the retail centers that already exist in the state? I'm not advocating for that. I'm an academic. I said, let's just think about that. Let's run some numbers. Let's look at those possibilities.
Well, I can tell you, those of us that have to get elected in Tennessee, that's a non-starter.
Unless you have to get elected from a place that's not getting much local revenue.
Sir, the majority of states use destination sourcing for all sales. And it's more complicated because you have to know what the sales tax rate is at the door. But you get a much more accurate reflection of the use of the thing that was purchased. When you live on a farm and you drive to town, you have to buy parts in town. That farmer gets nothing from that city. At least that's what they used to tell me when I was talking to farmers when I had that job. Clearly, all the money that farmer wants to support, all the government services that farmer wants to support, is outside near or close to their farm.
Well, I support.
Destination sourcing is much simpler. There was a time when destination sourcing was very complicated to do because the technology wasn't there.
Exactly.
That has changed.
Right.
The technology should not be a reason why people not change tax policy that you didn't change because there was no technology.
And I think that's why we came to that agreement that it should be destination, should be based on where the individual lives in that jurisdiction, because they are consuming whatever those benefits are from living in that jurisdiction. So that was our thought as well. And I appreciate, Mr. Bruce, your explanation of what you meant by revenue, and I certainly agree with it as defined there. Thank you. Thank you, Mr. Chairman.
Okay, we have Mr. Huffman and then Representative Carter.
Thank you, Mr. Chairman. Commissioner, let me ask you, does the General Assembly have the ability to change the $500,000 threshold?
Yes, sir.
It does?
Yeah.
When you're collecting the state sales tax from internet retailers now, do municipalities in Tennessee get 4%, roughly 4% of that state sales tax as well?
Yeah, it is. It's 4.6% of the revenue generated by 5.5% of the sales tax rate state, but it's roughly, you could call it roughly 4% of the state sales tax is shared with cities based on their relative population.
Yeah. Have you seen an uptick in sales tax Tennessee collecting sales tax from internet retailers since the Wayfair decision?
Anecdotally, we've seen some folks register who we think probably registered because of the decision. I think it's a little early to say what that's going to look like, but anecdotally, we've seen some registrations we assume are because of the decision.
Does your department have the technology, the ability to locate someone who's bought something over the internet, who's in a municipal zip code, but actually outside the municipality? Someone who lives in the county but has a city zip code?
I think if I could answer that this way, when those out-of-state sellers who are reporting to us based on their customers' residence, they're using a GIS-based database that we maintain and work with the comptroller, get their help with, that we make available, and it is not based on zip code. It's based on actual residential address.
Yeah. And then just my last question, Mr. Chairman, if the General Assembly doesn't move back the July 1, 2019 date on streamlined sales tax, on July the 1st, what happens?
So a number of changes take place, and it's several. I think maybe the best way to answer is highlight a couple of the significant ones. One we've already touched on. For those in-state sales, we would switch from origin-based sourcing where the store is to destination-based where the customer is. So that would change the jurisdiction that gets the tax on those sales, and it would require the retailer to report to us where their customer is located. So it's an additional requirement on the retailer, and it shifts revenue among local jurisdictions. So that's one big thing that would happen. The other big thing has to do with the local option single article cap for local sales tax. Generally, if you buy a big ticket item that costs more than $1,600, the local tax is capped on at that first. This gets pretty complicated pretty quick, but there's local tax applicable to the first $1,600 of the purchase. There's an additional state single article tax that applies to the next $1,600, and then there's no tax except for the 7% state rate above $3,200. Okay, so there's a cap there.
Yeah, excuse me, Commissioner, let me
Yep.
just, to make sure I understand, between 1,600 and 3,200, there's a state tax?
Yes.
That's the same as the local option tax?
It's 2 3/4%.
And the state gets that?
Yes,
right?
yes.
So the state has a 2.25% sales tax on a single item between $1,600 and $3,200.
Yeah. Keeping in mind that the 7% state rate applies to the whole purchase price.
Right.
But we're talking about the local tax. The local tax applies to the first $1,600, then it's capped and it no longer applies, but then there's a substitute state tax of 2 3/4 that applies to the purchase price between $1,601 and $3,200. And then above $3,200, there's no additional tax. It's just the 7% state rate. So that's the single article cap. And that is not something you can have under the Streamlined Agreement. So when all this legislation was passed in 2003, there had to be something that had to be addressed, and that will go into effect July 1 if nothing happens. And so what the July 1 provisions would do is if it's a consumer good, say it's an expensive piece of jewelry, that cap is eliminated. So the state rate and the applicable local rate will apply to the whole purchase price. Local governments will see more revenue from that. The state will lose that state single article tax, right? So it'll be taxed just like, there will be no cap. If there's an exception for that, for automobiles and boats and planes, they can, under the Streamlined Agreement, have a cap, and they would continue to have a cap, okay? So we're not talking about cars and boats and planes here. Those would remain the same as they are today. So that's for the consumer. The cap would go away on a piece of jewelry, would remain on a car. For a business, the cap goes away, and so say you're buying an expensive piece of equipment, you would pay to your vendor the full state and local tax with no cap, but each year you would have the ability to come directly to the Department of Revenue and ask for a refund of the difference between what you paid to the vendor and what you would have paid if a cap had been applied. And you can get that as a refund. That's very problematic for a couple of reasons. One of the biggest is you pay to your vendor, and that local tax goes to a specific jurisdiction, but when you come and ask for a refund, we have no idea which jurisdiction the money went to in the first place. And if you have multiple large purchases, it could have gone to multiple jurisdictions. So we have no way to know what local tax to a particular jurisdiction is being refunded. So that was a provision put in place, but it is viewed as pretty problematic, pretty complicated and problematic. But that's what would be the law if nothing changes on July 1.
Thank you, Commissioner.
Thank you, Mr. Chairman. I've spent the last year or so in discussions on this, wondering what we're going to do with the money. And today I'm thinking, oh my gosh, what have we done? My concern is if I have a retailer in my district, and I think you mentioned some state had 72 separate taxing authorities in it. What if all 72 of them send my constituent an audit to see that they're properly referring the tax proceeds to Colorado? and then California and Ohio and then Indiana also. Are my small businesses going to spend all day performing audits for other states?
Would you like for me to? Representative Carter, I think in theory, any state could audit a taxpayer who is subject to their law and collecting and filing a return. Certainly states do today have out-of-state companies that collect and do audits. I do think, my thought on that is there is the issue of resources, though. States can only audit a small percentage of current retailers. So states won't necessarily have the resources to send auditors to all of those businesses. But in theory, you're exactly correct. And in practice, there may be more auditing. I'm just adding to that there's a limit on the number of auditors and the resources of states to conduct audits.
Yeah, but you could send just a starting email, forward your last 3 tax returns.
That's true.
All of your checks. I mean, I just see an absolute nightmare. And of course, knowing that, or I guess as a recovering attorney, that this is a real can of worms that's been opened. I don't know how we do this without affecting interstate commerce, which is the first no-no I learned in law school, that states can't do that. So I was interested in the comment that was made that they didn't say it was okay. They just said we're reversing what we did before. I'm really afraid if we jump out there and amend the law and set up for what we think it's going to be in 2 or 3 years, Supreme Court may tell us, no, you're affecting interstate commerce and you have no right to do that. So I'm more baffled than ever, and I appreciate, I mean that complimentary to you, not, it's just raised issues that heretofore I had not considered. I've just finished a 21-month audit with a constituent of mine and with the state, and they did a great job. They were extremely thorough, but why couldn't that have been Ohio, Indiana, Missouri, anyone else? And I just don't know. This young man spent so much time working on it. I just don't know how he would do that more than once a year and literally survive.
Representative Carter, if I might, everything you said is certainly, actually, it's the rule today. There's no reason why those cities in Colorado couldn't be auditing your constituents now if they think for a second that their constituents making a sale in there. One of the good things I think that exists today is the way audits are conducted. They're not sales tax audits. They're use tax audits. I did a survey of all the states 4 years ago, and 80% of all audit assessments were use tax. The tax that should have been charged by a retailer when a business bought something for the business's consumption. Very little of a sales and use tax is actually about sales. There may be a lot of effort that goes into that, but there's very little tax that comes from that, because getting the right taxability and getting the rate right is usually pretty straightforward. Or you're going to get really close, and when you get close enough and you've collected the tax, the department will work with you to make sure that the money gets moved around to where it's supposed to go, or whatever. But with more sellers collecting sales tax, there will be fewer businesses that owe use tax. And the entire nature of sales and use tax auditing is going to have to change, because there just won't be the money to collect that is there today. It'll all be collected in the form of sales tax. So there may be things that people look at from exempt sales. Exempt sales are the number 2 thing that auditors look at when they're doing a sales and use tax audit. But I'm actually hopeful that the effect in 5 years from now is that there are fewer audits and not more. There are more people doing audits, perhaps, but there's going to be a lot less money, because there's going to be a lot more people collecting sales tax, and it just won't be worth anybody's time to fly to your city and conduct an audit for someone who might have got the rate wrong 2% of the time. I think this is a positive thing, but you're absolutely right. There's no reason. This will be the next thing. Origin sourcing will be the first thing. Local economic nexus, or local nexus, will be the second thing. And then the effect of an audit will be the 3 things that lead to the next
the U.S. Supreme Court decision.
It's going to be an interesting time. Thank you, Mr. Chairman.
Mayor Vickers.
Ms. Pearson, I want to follow up. You used my lovely city a couple of times by example, and you're right. Every day, there's a steady stream of our residents going to the post office, shipping out some, I'm sure, is small items that they're selling on the internet through Etsy or one of these other sites. But when they do that transaction, by definition, they have to use a credit card or some other payment provider, right? And they're paying a fee for most of them, whether it's Square, PayPal, Amex. They're already paying a transaction fee for each, no matter if it's a $10, a $15 item, they're already paying a transaction fee. Is that right? Yes. And do I understand that there are companies like yours that are certified to assist sellers like that, so that if they get a sale for a specific postal address in Kentucky or even in Wallen, the software is there, they plug that mailing address information in, and it calculates what the sales tax they should be charging for that item.
Correct.
So there's really, and that would just be a fee-based, I suspect, either quarterly, annually, or transaction-based from a provider like yours that seller would provide.
Yes, we charge, there's two components to our fee. One, transaction, so there's a tiny charge for each transaction they run through our system to get a tax, and then there's a fee for filing a return. And it's a la carte, they can pick one, they can pick it all.
And usually my good friend, Representative Carr, and I see eye to eye on things, but would that, if there is a situation of an audit, would you not be able to provide the report to the person who has paid you that fee to show this is, the state of Kentucky or this state has asked for you to provide, and you can say, as part of what you do, here's what we paid, even by transaction, if the state wanted that much detail to show that the correct tax and rate had been applied?
Yes, and there's three different ways that we do this. One, we do it through the Streamlined Sales Tax. So we're a certified service provider under the Streamlined Sales Tax, which makes us the seller in the laws of the 24 states that are members of Streamline. And so those states actually audit us. They look at all the transactions that have run through our system for their jurisdiction, and then they pick and choose which one of those transactions they want to look at. And I mean, it's a normal audit. And our job then is to prove that we charge the right rate, or if we didn't charge a rate at all, to prove why the purchaser was truly exempt. In our non-SST business, we make that part of the things that we'll do for people. But yes, we can. The issue, and the rest of the world is moving more toward that concept. That a lot of the world is moving toward actually where the government's actually in the middle of the conversation, and the government is approving the transaction, which is not a concept that I think would go very well here. But the volume of transactions that exist in the retail trade today is so huge that there isn't a state computer system that can handle it.
Okay. You mentioned the different threshold levels that kick in the various state jurisdictions. It sounds like if someone uses a company like yours, the transaction fee is probably going to be close to the same whether they have $10,000 in sales by, is right. I'm struggling to understand what the difference in the burden would be if it's a transactional fee, most of which is going to get passed on to the consumer, versus, for $100,000 a year internet sales company versus a $500,000 a year internet sales. It sounds like the technology is such that there's not much difference in the burden in compliance between those sales. Am I missing something there?
Mary, no, from the burden perspective, no, you're right on target. There is absolutely no difference whether you make one sale or 1 million sales. There will be a different price that you pay us because we're transaction based, and the transaction is getting the tax amount. So if you make one transaction for $1 million
you'll pay one fee. If you make 1 million transactions for $1, you're going to pay a higher fee.
But I would presume that just like the payment processing fees we pay, that would be something that the person selling those small items list would have to factor into his cost of doing business to determine whether or not it was economically feasible to make sales of those small items across the country, right?
That's true, but that hasn't been our experience. Folks are looking at what they sell. They've got loyal customers. They're their friends, and they sell it to them, and they just eat the cost.
Okay.
I'm glad you asked the question about the thresholds, though, because I wanted to respond to your comment about the threshold, the $500,000. In the brief that South Dakota submitted to the United States Supreme Court, they said that a $100,000 company in South Dakota would be equivalent to a $30 million company nationwide. They didn't do that because they thought $100,000 was the right number or $30 million was the right number. They did it as an example. And so what has come from that is this conversation about, well, if it's $100,000 in South Dakota, it should be $500,000 in Tennessee, and it should be $3.5 million in California. When I talk to my lawyer friends about what due process means, because what the court wants to do is get to a due process test, they're saying, if $100,000 creates a due process connection with South Dakota, why doesn't $100,000 create a due process connection with California? The due process part should be identical. So I think over time, pardon me, over time, whatever the threshold is today will go down. You will get to a spot where folks are using us and our competitors, and the actual ability to comply becomes moot. Maybe the cost of compliance is an issue, but the ability to comply becomes moot, and you will start to lower those thresholds down.
Because where I'm struggling with the whole concept of, it sounds like there's really no greater burden between 100 and 1 million. You know, if someone wants to set up and sell ice cream cones in the summer to the people going and enjoying the lake, they may have limited sales, but the state still expects them to charge and collect the same sales tax as Walmart or anyone else who does multitudes more in sales. So I'm struggling with understanding why if the burden is, there's no real difference in the burden, why we would even have such a struggle with trying to determine what the threshold should be. Why wouldn't we just make, just like local brick and mortar, everybody who does a sale needs to calculate the sales tax and charge that to the consumer and let that consumer pay that as part of the transaction.
That's politics in irony, because that's one of the issues that the Supreme Court has struggled with since they first established physical presence. They said you can be the least sophisticated retailer on the planet and have to collect sales tax everywhere, because whatever you do, you have to do in person. And you can be the world's largest retailer and never collect sales tax anywhere because you never have to be present.
Okay. Commissioner, I've got a couple questions for you, if you would please. Currently, I can audit to make sure my municipality is collecting the local sales tax it's supposed to get, because I can request a CITUS report. It will identify the retailers or the people who have submitted or showing as local sales tax CITUS people in my municipality. I can look at them, and some of them, and by the way, y'all have gotten tremendously better when you went to the GIS model as opposed to what you had before. It's rare now that I look at it and I see, you know, with our municipality, we have 2 cities in the county, the same zip code. And so it was confusing at times. You know, there would be people who ended up in the wrong place. But I can now take that list, we can use that against our business license database, and I can tell you pretty quickly, are there people who should be on there who aren't? And that would help us notify the state that we need to follow up. If we have the internet payers today who are paying the 2.75, which is what it is in Blount County, what mechanism do we have to do the same form of audit to make sure that we're getting that those dollars are coming to us as we do with brick and mortar folks?
Yeah, Mayor, so the same report that has your brick and mortar folks will have, and it has today, the retailers who are reporting to us the jurisdiction, that 40% that are reporting to us that jurisdiction-specific rate and information, so we're sending that money to you. Those retailers are in that same report as your brick and mortar, so you can look, you should be able to look at that.
I appreciate it. So just say, for example, Amazon does that, it would show Amazon as one of the retailers in the Southport. But if the tax is being collected by place of delivery, how do municipalities or counties know that the taxes that are being collected and then redistributed by the state are accurate? Because we don't have any idea what the residential or place of delivery is.
Yeah, you know how much they reported for your jurisdiction, but you don't know which residents that was, sales to residents that was based on, or whether those were accurate. That is true. I don't think there is a way for you to know that.
But they are using your all's GIS model. Is that correct? When they're trying to determine who the location of the 2.7, the ones who don't use the formula, are they using the same GIS model that the state uses with brick and mortar?
We make it available. I think Scott maybe wants to weigh in.
So that particular company uses one of our competitors, extraordinarily good company, but they create their own map. They have their own data, their own resources, their own teams of people that are following the annexations in Tennessee to make sure that they know where the boundaries are of those cities. Each of us does the same thing. There's, I think there's 9 of us in this business today. 1, 2, 3, 4 of us have our own maps. 5 use the departments. But we should all get to the same answer if it's done using an address that goes to a GIS system. When you get to, latitude and longitude is exact. You can't be wrong there. Where there is an error that exists in the software today, it's in converting, getting to the address, getting the right address. There's several companies out there that provide a service to us and our competitors that turn that address into a latitude and a longitude. They don't all use the same they don't use the same process in the background to get that. Sometimes they rely too much on the post office. They don't do their own research. Post office, frankly, doesn't care. It's not their job to care what their addresses are. Their job is to get the mail out.
Right. And just one more question, and I apologize. Sometimes we have to make things simple for me to understand them. I would think, it seems to me that when I order something on Amazon or on the internet, that the information they gather about me from my address and the 9-digit postal code, I get the sense they know just exactly where I am, and if they had accurate GIS mapping, it shouldn't be much of a challenge for them to know, you know, Vickers lives in the city of Louisville, his buddy lives out in the county, but also has a 3777 zip code. Am I missing something there, or is it just that we had the technology there, but it just needs to be implemented, I guess is my question.
That particular company has great technology. If they're going to be wrong, it's going to be very unusual, and it probably won't be something that's their fault. It's the fault of the company that provides them with that technology.
Okay.
There's going to be mistakes. Anybody that uses a 5-digit zip code will be wrong almost all the time. Anybody that uses the 9-digit zip code is going to be wrong 25% of the time. Our experience with 9-digit zip codes is they are great inside city limits. 5-digit zip codes, well, so I'm from Grizzly from South Dakota. There are 2 5-digit zip codes in South Dakota that are wholly inside of a city. 2. There's thousands and thousands and thousands of 9-digit zip codes that aren't anywhere close to inside a taxing jurisdiction. So you've got to use the latitude and longitude. To the extent that somebody's in this business that's not using latitude and longitude, they're going to get that wrong. And, you know, that's what David's team will find out, you know, 3 years later in an audit.
Okay. Well, thank you very much for both for your presentation and for your answering my questions. Thank you.
Okay, further questions, members of the commission? Okay, hearing none, gentlemen, thank you very much. We appreciate you all being here today, and very informative and very good. Thank you.
Thank you.
Okay, we will move to the next item, which is in tab 4, which is our election study update, and we have Jennifer presenting that to us today.
Senator Nicely's letter to the commission, there we go, which is included as Appendix A. He expressed concern about new threats to Tennessee's voting system and requested that the commission revisit and update its 2007 staff report titled Trust But Verify, Increasing Voter Confidence in Election Results. The 2007 report took an in-depth look at election security in Tennessee and included several findings and recommendations. The report brief is included as Appendix B. Senator Nicely said that he does not feel we need a comprehensive study, but only a staff report to update a narrow section of the 2007 study addressing 2 specific topics. Senator Nicely's first topic is the most cost-effective and efficient voter-verified paper audit trail, or VPAT, options for Tennessee counties. And his second topic is opportunities to offset VPAT costs with the use of secure electronic transfer, a system used by 35 states to ensure that data from all agencies is available to verify the accuracy of voter rolls. And just a quick review, a voter-verified paper audit trail, or VPAT, is a paper copy of marked ballots for voters to review before they actually cast their ballot. Tennessee law does not require VPAT, but allows counties to choose the type of voting system they use from a list approved by the Secretary of State. 14 counties currently use VPAT systems, and several others are considering or are in the process of replacing their equipment. And regarding Senator Nicely's second topic, secure electronic transfer is a system that digitally transmits voter registration data from state agencies that process voter registration applications to county election commissions, which then use the data to verify and update voter rolls. The Driver's Services Division is the state agency that does this most commonly. At the September meeting, I presented preliminary information that addressed the 2 topics, and now I will cover new information that has been added to the staff update to address questions and concerns that commission members brought up at that meeting. Because this is a staff update, not a commission report, a vote by the members is not required. But as always, we appreciate your guidance and input. This final staff update says that TACIR staff continues to support the recommendations in the 2007 staff report, which is in bold print on page 3 of the update. Although none of the recommendations in the 2007 staff report addressed secure electronic transfer, 3 addressed the use of VPAT. At that time, staff recommended that Tennessee implement voter-verified paper audit trails statewide within a reasonable time frame, adopt VPAT that can be counted by hand as well as by machine, so that machine tallies support prompt reporting of results with hand counting for audit and recount purposes, and adopt a standard for VPAT that would meet federal guidelines then under consideration. TACIR staff continues to support these recommendations, and further, staff would encourage county election officials not wanting to replace their current non-VPAT machines to consider adding printers to make them VPAT capable. And regarding Senator Nicely's second topic, rather than relying on paper voter registration applications, although the cost savings are not clear, staff encourages the state to continue implementing electronic voter registration processes, making it easier to register, improving accuracy of voter rolls, and potentially saving money. The state has recently implemented some electronic processes that securely transfer registration data, but continues to use paper applications during many voter registration transactions. Up next in the update is a new section about how the risk to election security has changed since the 2007 staff report and since the Voter Confidence Act was passed in 2008. Tennessee is not immune to security threats, as the website crash in Knox County on election night back in May of this year illustrates. The weakness in the election system was repaired, but the lingering concern is that the website crash and delay in election results create the image that elections are being hacked and are not secure, potentially eroding people's confidence and trust in the election system. And because Knox County uses direct recording electronic, or DRE, voting machines without Vpad, like most other Tennessee counties, there is no paper record of votes that could be used for an audit or recount if necessary. Security of election systems, including voting machines, websites, and registration databases, has continued to be a major focus and concern in Tennessee and at the national level. Even though Vpad is not federally mandated, in August 2018, U.S. Department of Homeland Security Secretary Kirstjen Nielsen called on, and this is a quote, all state and local election officials to make certain that by the 2020 presidential election, every American votes on a verifiable and auditable ballot. We also added some additional information throughout the staff update to help clarify a few points. On page 3, we added definitions for voter-verified paper audit trails and secure electronic transfer. And we added a table on page 6 describing types of voting systems. Appendix F includes descriptions with photos of different types of voting equipment. There's now more information about cost considerations on page 9 and a new appendix, Appendix H on page 43, with information from the National Conference of State Legislatures about evaluating the purchase and cost of election systems. There's a new table, Table 3 on page 10, that summarizes the type of voting systems that other states use and the statutory requirements in each state. All but 4 states are using some type of paper ballot system in at least some jurisdictions, although not all require it by law. 30 states require either paper ballots or VPATs for DRE machines. 14 don't require either, and 6 require a permanent paper record but don't specify whether it has to be voter verified. Several states are considering or are in the process of replacing their non-VPAT equipment with equipment that produces a VPAT. In response to a concern expressed at the last meeting that staff had talked with counties in Tennessee that use VPAT, but not with the counties that don't, staff spoke with several county election administrators across the state that use DREs without VPAT. Overall, these administrators feel confident and satisfied with the DREs machines that they use that do not produce a VPAT and do not want to replace their equipment with VPAT equipment. Although some said that the cost of replacing equipment is a major concern, others said that even if funding were provided for VPAT by the state or federal government, they would prefer to keep their current systems because they believe they are secure, reliable, and efficient. Some also said that if VPAT were mandated, they would prefer to use add-on equipment available for the DREs, such as printers that create VPATs, because it's cheaper and easier to implement than optical scan systems, particularly the systems that use pre-printed ballots. Now moving on to Senator Nicely's second topic of whether secure electronic transfer could offset the cost of VPAT. We added more detail about the potential savings in Tennessee and examples of savings in other states on pages 11 and 12. It still remains unclear how much money, if any, secure electronic transfer or online registration would save the state and local governments over time, and how much of the cost of VPAT could be offset in Tennessee. We updated information about funding Tennessee has received under the 2002 Help America Vote Act, known as HAVA, Appendix I on page 45 shows how much each county received from the 2002 HAVA allocation and which counties have funds remaining as of November 2018. The state also received $7.6 million in new HAVA funds in 2018 under the Consolidated Appropriations Act. So we added Appendix J, which is the Tennessee Secretary of State's 2018 HAVA Election Security Grant Program narrative that provides more detail about how the state plans to spend these new funds. And in closing, to briefly summarize the staff recommendations, TACIR staff continues to support the recommendations related to Vpad in the 2007 staff report, encourages county election officials to consider adding the printers when they are available to the current non-Vpad machines, and encourages the state to continue implementing electronic voter registration processes. So thank you for your guidance and input on this staff update, and I'm happy to answer your questions.
I've had a couple of election commissioners from a couple of counties contact me, and they just bought new machines, and they're concerned of the cost. Do we have a physical note or is that just hard to come up with at this time because it would depend on the system that the county would go to, a physical note that this would entail?
There was a fiscal note on the bill that was introduced last session, but as far as coming up with a cost for each county, there's a lot of different variables, so it's going to vary depending on the county, what equipment they're using, how much in HAVA funds they still have remaining.
Okay. My only comment would be whatever California's doing, we need to do the opposite because they're still counting votes out there from November. I don't think they're ever going to finish. It doesn't seem to me to be a complicated process, but obviously it is. But so we don't have a physical note, and looking through this, there are systems that can be bought that would integrate into the present system. Is that correct?
Correct.
And do we have an idea of the cost of those systems?
Well, there are basically three systems that produce voter-verified paper audit trails. There's two types of optical scan systems, and 14 counties use those currently. And the other systems, the other possibility is adding a printer to the DRE machines, which if you already have a DR machine, that would be the most cost-effective option. And I mean, as far as a dollar amount, I've seen ranging amounts for those printers. But that technology is available, however, not approved yet in Tennessee. It would have to go through our approval process and get on that list, the Secretary of State's list.
Okay, yeah, Representative.
Thank you, Mr. Chair. Do we have a side-by-side comparison of the counties that still have HAVA funds available versus those that have not implemented a more secure machine?
Yes, so Appendix I on page 45 shows the amount that counties received, which counties still have funds remaining.
Right, and so I see here, the table that shows which counties still have funds remaining, but how do we know what kind of machines those counties have?
I don't have a side-by-side.
Can you get us one?
That's a good idea, yeah. Appendix G is the list of all the different types of equipment that each county uses, but I don't have that side-by-side.
Is it possible to produce one, though? I'm just asking.
Yes.
Okay, and one last question, Mr. Chair. We're not voting on this report, am I correct? I think that's what you said earlier. So what are we supposed to do with this information?
Well,
as a body?
Cliff can probably address that.
Well, since it's a staff report, of course, it'll be available on the TACIR webpage with the rest of our publications, and we will report back the updated staff report. Will make Senator Nicely aware that it has been updated, and that's really the only action that the commission has to take on it.
Okay, last question. What was Senator Nicely's intent for bringing these questions before TACIR? Anybody want to speak for Senator Nicely?
It's always a dangerous question in the legislature to start speaking to Senator Nicely's intent, and I'm not going to make any attempt to do so. But I mean, I think that this follows up on discussions that were had last year. He proposed legislation that would have, there were two different iterations, frankly. One would have required all counties to get to some form of voting with a voter-verified paper audit trail, you know, by a date certain. A second version, which I'm not sure if it was like actually made it to file or not, but was an amendment, would say any replacement machinery that's purchased by a county needs to meet the voter-verified paper audit trail standards. So those were the two. So I think that given where we were and like the conversations that were developing, I think we were trying to get a sense of, you know, what's the best practice here, because there are these different means of using of achieving the audit trail, and trying to figure out where the cost effectiveness, you know, potential is within that. And just to speak to the only other question, that while it's not a side-by-side, the Table 2 on page 7 seems to have the 14 counties that do have some sort of paper audit trail for votes. And so if you look at the 14 counties where that is, you can then look at the counties that have, you know, HAVA funds remaining. It's not side-by-side, but like it's not too hard of a comparison. But thank you very much for the assistance. I mean, this is, you know, I mean, obviously there are security issues, but I was reminded around election time, you know, having, maybe, I don't know if other people who have run for office have been part of recounts, but it's, but having been in a close recount, the ability to sort of know that you're, like, you know, when it's a close margin, being able to, like, actually do a recount and not just rerun a computer program on a machine is actually, like, kind of provides some reassurance, so.
And I can comment at Sevier County, we just bought this new system, and it worked well. It's a paper. You do it electronically, and then it spits out a paper that has all your votes on it, and you review that to make sure it's correct, and then you walk it to a person who puts it in a machine, and you have a paper trail. Of course, we did that. We went kicking and screaming and did that because we bought new machines about 4 years ago, and our election commission came and said, we want to do away with all those old machines and buy these new machines but we did get a grant to do that, but it works very well. I mean, the system did and has a paper trail, but it is fairly expensive. Yes, Claire.
And I'd just like to add, Jennifer pointed this out when she was going through, but I would refer the members again to Appendix F, starting on page 35, if you have any questions on the differences between the technology, because this is a nice appendix that even has pictures for those of us who are, you know, visual people, describing how the differences between the different technologies.
Okay, further questions from the commission?
Just one. Do you know how widely or how many counties do or cities do voter registration electronically?
That's a good question. Well, every county. I mean, so online registration is one way to register electronically, and that's available everywhere, obviously. And then it would be, it's then through the driver services locations, and not every single driver service location has the kiosk where that electronic registration happens, but I don't remember the number, but they're scattered across the state, and I don't think it's every single county. I don't know the number, but I think I could find that information.
But most counties do have that as an option.
Yes.
There. Do you see, I know you're recommending that as staff, do you see that would be a requirement or something? I don't know that you could really say it's required that all voter registration be electronic registration.
I think the General Assembly could say that if it chose to.
My question there is, would that inhibit what I would call in-the-field registration? like, what do you think?
I mean, I don't, so one question I have is, and I don't know what the national law is like if there is any requirement I don't think there is for paper registration. I can't imagine that we would go to, I'm not sure if we'd go to exclusive, but I mean, I think that making it the dominant means certainly has that advantage of not having the glut of paper that comes in, and especially because it comes, it's not like one of these registration forms comes in each day over the course. Like, it turns out that almost all of them come in, at the times that are already the busiest for these committees. I do think that the groups that get involved in this regardless of which side of the aisle or be nonpartisan or partisan or whatever, a lot of them are moving to having kind of a device where people can do it. I mean, you could use a phone, an iPad, or something like that tracks it. And so, I mean, I think people could do it. The challenge is that, but some people prefer to do the papers method. So, I mean, I think you would see different groups or volunteers wanting to do different things. The one piece that really stands in the way of online voter registration being the dominant form used by the groups that can get involved in it is that what some states have done have created sort of the public-facing interface where you can, where you just go to the national webpage for Rock the Vote or whatever, or the League of Women Voters, and enter your information, and the computer systems tie into each other. I think it's like an API or something like that. But and so you transmit the information directly into Tennessee, as opposed to having to go to the precise Tennessee website. And I think that, I don't know what the status of that is, because, I mean, I don't know if there's a security issue in having it go the other direction, but that's why you still see a lot of the groups use paper, is they don't want to, most groups that are spending time doing it want to capture the information of the people that they're registering so that they can continue communicating with them, and just redirecting them to a different website doesn't achieve that. And so if you just have the state system and not the thing that allows groups to use an electronic system, then the incentive structure works so that people just continue to use paper.
That would be my concern too. I think you would need to have one site, one source, and I think it would help us move toward what I think is voter verification, so that it would improve the system. Most definitely.
And I guess, and this is where it's dangerous to speak about technology when you're not that, but it's not done on a different site. There's just one site to register, but the information that's inputted, that's input into a third-party vendor, is then transmitted directly into the Tennessee system to go through that one single verification process. But that's, I think the technological issue that I haven't spent much time, I haven't had a conversation with the Secretary of State about it, but that's, I think, the challenge that our counties are going to have, is that if we don't find a way to kind of do that, you're still going to, even if you have the availability of online registration, you're still going to see, spikes in paper registration toward, at the election crunch time.
I think we all know it's the wave of the future. We just need to be sure we're doing it in a secure manner, and then education, and involve our libraries and things like this. So thank you very much.
Okay, further questions on this issue? Not, thank you very much.
Thank you.
Good job. Okay, we will now move to tab 5, which is Public Chapter 179, the Acts of 2017 Boat Titling Update. And we have Nathan with us to...
Thank you, Mr. Chairman and members. This is just a quick update memo on the boat titling report. This memo is behind tab 5. As you'll recall, the Commission's report recommended that the state establish a boat titling system. And while the stakeholders and the relevant government agencies agreed that a boat titling system would be beneficial to consumers, the government agencies that potentially would be tasked with administering such system did not all agree about which agencies should administer a boat titling system. So the commission requested that TWRA, the county clerks, and the Department of Revenue try to come up with a consensus on who would administer a potential boat tiling system. So since then, TACIR staff has continued to discuss the options with the three parties regarding how a potential boat tiling system would be administered, including several conference calls, and we also facilitated a meeting at TWRA headquarters with all three parties. And at this time, however, the three parties' positions remain unchanged, and there has not been a consensus reached by all on the best way to administer a potential boat tiling system. Please let me know if you have any questions.
Okay, any questions? It's surprising that three different departments can't
Yeah.
get together on something. I mean, that's very unusual, isn't it? Any questions? If not, thank you. Okay, yeah.
Still here.
Don't leave. The next one is discussion of Public Chapter 849, the Acts of 2018 concerning the statute of limitations. And this is the final report for approval by the commission. So Nathan, go ahead.
Thank you, Mr. Chairman. Today I'll be presenting the final report for your approval. The commission's final report and policy recommendations on Tennessee's criminal statutes of limitations, which are simply time limits for bringing criminal charges. And this report is behind tab 6 in your docket books. And this report was directed by Public Chapter 849 of 2018, which directed the commission to perform a study on Tennessee's criminal statutes of limitations and specified that the study include information on the effect of statutes of limitations on the prosecution of sexual offenses. As you heard at the last meeting, the report was prompted by the testimony of a child sexual abuse survivor whose perpetrator escaped prosecution because of the state's statute of limitation expiring before the crime was reported. As you recall, I presented the draft of this report in more detail at the last commission meeting, and no changes of the draft report were requested by members. Therefore, there were no significant changes other than the addition of a new table added at the back in Appendix C that compares Tennessee's current criminal statutes of limitations for selected crimes to its neighboring states. So now I'll briefly go over the recommendations included in the final report, which remain unchanged from the draft report. These recommendations are found at the beginning of the report in the summary section and are shown in bold. So the first recommendation involves the second-degree murder statutes of limitation, which was not the primary focus of this report, but was brought up as an issue in interviews with some elected district attorneys. So under present law in Tennessee, first-degree murder has no statute of limitations, while second-degree murder, a Class A felony, has a 15-year statute of limitation. Some district attorneys generals have noted that this shorter 15-year statute of limitation for second-degree murder has blocked attempts to prosecute homicide cold cases for which evidence exists to prove that the defendant killed the victim, but not enough evidence to show that the killing was premeditated. Without evidence of premeditation, the state is prevented from attempting to find justice for victims of these cold case murders that are not solved within 15 years. So as shown in map 2 on page 19, in comparison, 48 states have no statute of limitation on the prosecution of second-degree murder. Only New Mexico has a shorter statute of limitation on second-degree murder. The report recommends that the state may want to consider either extending or eliminating the statute of limitation for second-degree murder. So the second recommendation is set up as a choice between two alternative policy options which both recognize the special circumstances of childhood sexual abuse and legitimate reasons why a complaint often cannot be made until many years after the abuse. So the first option is that Tennessee should consider fully eliminating the statute of limitation for most felony child sex abuse crimes, as has already been done in a majority of the other states. Or the second option is that alternatively, Tennessee should consider eliminating the statute of limitations for felony child sexual abuse crimes in circumstances where corroborating evidence is obtained by the prosecutor, similar to Oregon and Massachusetts' law, which would still provide additional protection from unfair prosecution. And if corroborating evidence is not obtained, then the statute of limitation that is otherwise in place would apply. So to provide an example of this, Appendix D shows Oregon's law as an illustration of a state that recently implemented this. So now I'll turn to the final recommendation in the report, which addresses the correction of a drafting error in Tennessee's current law. And to be certain of this, we confirmed our understanding of this drafting error with legislative attorneys and prosecutors. So as noted in the report, over the last decade, while Tennessee has not fully eliminated its statute of limitation for, or while Tennessee has not fully eliminated its statute of limitations for most child sexual abuse crimes, it has extended them to either 25 or 15 years after the victim turns 18. And for rape offenses committed against minors considered the most serious sex crimes, the state eliminated the statute in 2014, but placed a condition on the elimination. The victim must notify law enforcement or the district attorney of the crime within 3 years after it occurs. If not, the limitation period otherwise in place would apply. The legislative intent was the age of majority plus 25-year limitation period to remain in effect for rape of minors not reported within that 3-year window. However, an apparent drafting error in the bill resulted in the statute of limitation for these crimes not reported within that 3-year window, reverting to the shorter general default periods of 15 years for Class A and 8 years for Class B. So with that background provided, the report recommends that at a minimum, Tennessee law should be amended to clarify the drafting error found in current law. And the final report explains this in more detail starting on page 15. So that concludes my presentation. If you have any questions, I'd be happy to answer them.
Okay, questions from the commission?
Mr. Chairman, if we approve this, then we are saying that the legislature can choose between the two bullets on page 2. Is that correct?
Yeah, that's correct.
So they can either choose the one or the alternate number 2, the second bullet.
Let me make sure I'm on the right
Does this
page.
committee ever make a strong recommendation as to which one of those that we would like the legislature to consider? Or do we just, we've done the research?
Go ahead.
Our thoughts on it were that either recommendation would have a similar intent. And obviously, of course, the legislature could do either of these two things or something similar or something completely different. But we think something in this direction is what we would recommend based on what other states are doing and based on the research. We didn't have a strong preference for one over the other.
Okay. But whatever that we do, what we're saying is we're going to rectify an error. And then the other is that it will be stronger than it was before.
That's correct.
Yes, and my opinion is that if the commission wanted to amend the report to recommend one of them, that would be appropriate. If somebody wanted to make that motion and second it, and the commission voted to amend the report, then we could approve the amended report would be the way to do that. Yes, Mr. McMahon.
Thank you, Mr. Chairman. And just to clarify, on page 2, the first bullet, Nathan, it said Tennessee should consider fully eliminating the statute of limitations for most felony child sex crime. What's the differentiating factor there for most? What does that mean?
So there's almost 20 different felony criminal child sex offenses in Tennessee Code Annotated.
Okay.
So it's really a judgment call which one should be eliminated. Certainly the most serious offenses, the Class A and B should be, according to advocates. But it's really a judgment call.
But is so my point is, Mr. Chairman, is that if are we asking the legislature to make that that delineation and to say that so we take most out and that they say, okay, this is what's going to be covered and this is what's not going to be covered? Is that what we're asking them to do, or could we ask them to do that?
You could. And,
Okay.
and a lot of states have eliminated it for the most serious offenses, but have kept a longer statute of limitation in place for some of the less serious offenses. So It's really kind of all over the place.
Okay, that's what I was feeling. I appreciate that. Thank you, Mr. Chairman.
Further questions from the commission? Yes, Senator.
Thank you. And this may be an unfair question to ask, but I'm looking at the or the chapter, and it said the study would be directed to perform a study on the effectiveness of statutes of limitation on the prosecution of criminal offenses. So I don't see, and maybe I'm just not looking in the right place, where you've commented on how effective our statute of limitations are. By that, I would assume there would be some number of people who had attempted to bring a case forward and were prohibited from doing so because they were restricted by the statute of limitations. So how effective has Tennessee statutes been?
That's a good question. That's something we looked at, and we discussed in the report kind of the purpose of statutes of limitations. And one of the things we do note is that it is difficult to know how effective they are because the cases that are unable to be prosecuted because of the statutes of limitations are not recorded. So there's not a record of how many cases were unable to be brought because the statute of limitations exempted them. But in general, the report does discuss the purpose of them, the pros and cons, but there's no chart that lays out the number of the prosecutions that would have occurred but for the statute of limitation.
Okay, thank you.
Okay, further questions from the commission? Yes, Mayor.
Mr. Chairman, I would go back to the question of most. It gives me great concern if we, as a recommending body, use something as large as the word most, as opposed to specificity. And it's almost as though the alternative is more specific because of the word must than the original. So I just would throw that out. I know you're anxious to do a final report on this, but I do have concerns that's not spelled out. I don't know if that's something you could look at and bring us something back tomorrow or not, but that would be my concern at this point.
So I would say, on page 14 of the report, we have a table that lists all the felony child sexual abuse offenses. So if the commission wanted to change must or most to all, that's something that child advocacy groups would certainly support. That's what is a preferred option. The recommendation was kind of a conservative recommendation. And the second recommendation that involves corroborating evidence is kind of even more so of a balance between what the defense attorneys would want versus what the advocates would want for the child sex victim. So hope that makes sense. But
Mr. Chairman, even in that report, I mean, you look at the E's, sexual battery against a child less than 18 is an E, depending upon how that's brought forward. Just going by the felony class by itself doesn't portray the outrage of a community over something like this. So I would, if it's appropriate, offer a motion to accept this with an amendment to change the word most to all.
Okay,
I second that.
Okay, I'll accept that as a motion to amend the report to change most to all. Yeah, is the intent, Mayor, to strike the second option and just keep the first one?
Yes, and just say to eliminate all statutes of limitation with regards to child sex offenders.
Okay. We have a motion to amend this report to eliminate the second alternative there concerning child sex offenders, and you would have, and change the word most to all in the first recommendation. Yes.
Mr. Chairman, I
Mr.
second
McMahon.
that motion.
Okay, we have a motion and a second to amend this report. Now, do we have discussion on the amendment? Yes, Mayor.
Mr. Chairman, I think everybody understands the appeal of saying we shouldn't have limitations on bringing criminal charges in the most heinous and offensive acts, and first degree murders when we don't have one. But we shouldn't lose sight of the fact that the long-standing reason for statute of limitation is to appreciate that the longer the passage of time between the act in question and the prosecution, you have all sorts of issues such as a spoliation of evidence. Memories can go bad. And I think many of us watched, notwithstanding our political views, what happened in the latest Supreme Court nomination where allegations were made years and years and years after the fact. Many of those may well have been barred, or the person, the victim, had the understanding the psychological aspects of people struggling with sexual abuse, particularly children. But, you know, I think we have to be careful about not considering the impact on someone who 50 years later has someone who was 16 years old at the time. That person may be seeking a political office or a judgeship, or them deciding, well, the best way to sink that person, for example, is I'll bring, you know, a criminal claim versus what happened 40 years ago. It may well have happened, but the reason we have these limitations is we want to encourage them to be brought in a time that is conducive to the administration of justice. And to say that there are a wide range of sex crimes and sex abuse crimes, I'm not sure it's appropriate to lump them all together. I mean, the most heinous of them probably there should be no statute of limitations, but, you know, there's a reason that one's an E felony versus an A felony. I'm not sure that I would hope that before we took a position that we would at least maybe seek some additional information as to the impact on the judicial system and those who are accused. Because keep in mind, there's a difference between a statute of limitations and a statute of repose. We have both. A repose means once that period of time passes, nobody can go back, you know, you're free and clear. Limitations, there could be somebody who their culpability for a crime has been expired for 20 years. But if you change the statute of limitations, it typically applies retroactively, which means you could be free today and have no concern that somebody could bring a criminal charge against you if you eliminate the statute of limitations or extend it. Then that opens the window up again. I understand that, 15 years, is clearly offensive to me, that's too short. But I think I would urge us to exercise caution before, and I say this as a lawyer and an officer of the court and someone who's committed to seeking justice for all, that we take care before we go too far and say let's eliminate the statute of limitations for all these, because I don't think this report has explored that and the impact of that, at least with what I've read. So those are my comments, Mr. Chairman.
Thank you, Senator.
Thank you, and Mr. Chairman, I share your instinct, but I'm also appreciate the concerns raised, and it occurs to me as the mayor was making that point that we don't. It's not like we have a list of what of every offense that would be included. In front of us right now, and I wonder if we either, that language might be able to change to most or all, or something that's less complete.
So one approach we could take that would kind of bring in some of the practices from other states and some of the things that have been advocated by both prosecutors and defense. is kind of a combination of those two bullets that we threw out there. Perhaps something where it would eliminate the statute of limitations for all Class A and Class B felonies, and then all other child sexual abuse crime felonies where there is corroborating evidence obtained. And that kind of brings in that a little bit of a threshold element from that second bullet, so that you're kind of addressing some of the current concerns that Mayor Bickers had for some of those other felonies, and getting at the distinction between the classes.
Excuse me, Mr. Chairman.
Go ahead, Mike.
As the maker of the motion, I mean, I certainly appreciate my colleague's thoughts on this. He has experience and education in an area that I do not. But we both share the experience of our citizens who are faced with these terrible things with the technology that we have today, to determine that somebody did this, that the child may have made a vague representation as a child, and everybody blew it off, and now they're an adult and they can express it more clearly, and the evidence is easier to get at or to deal with the DNA and other things. This also, I mean, we've started here because of the request with child sex crimes, but I know in Memphis and across the country, the rape kits that were on the shelves for so many years because there wasn't enough money and not enough places to do those things. I mean, you got that also. The community's saying, well, wait a second, what about these situations? And so I'm certainly open to that discussion based on if we had some better clinical evidence. When I say clinical, I don't mean medical, but in regards to more specificity to what each of these mean, because to me, there's a great deal of difference between employment of a minor to distribute obscene material than there is against sexual battery against a child. So yes, I see differences, and I don't know how deep that goes in some of these other areas. To me, those are a lot more clear than perhaps those last two, but, well, to me, the last one is clear, but, so, I mean, Mayor, to your comment on that, what would be your suggestion as to how we would ask staff to get us enough information to make it, you know, I don't like leaving it necessarily open-ended. I mean, even though as a salesman, I would want to always ask, do you want it in blue or do you want it in green, rather than do you want it? Because they could say no to one, the other, they're going to maybe take one or the other. But in this case, because, as you say, people's lives are at stake, not only those who are offended, but those who are accused. So how would you recommend that we would proceed?
I think this is, I would think if this is a situation where we just need to be cautious and deliberate in how we proceed to make sure that we're not making I mean, we should hope that the legislature takes these recommendations with utmost seriousness, and I believe they do from ours. But, you know, and maybe, and one advantage of I think it's Oregon and other states' approaches is if additional evidence, you know, relevant, reliable evidence comes forward, such as the DNA kit that's been on the shelf for, you know, and keep in mind, you got, it's 18, because it doesn't run until they turn 18, then you tack the 15 on or whatever. If it's been on the shelf in Memphis for 20 years, which is hard for me, I mean, that's not acceptable, right? But it may be the reality that, you know, let that be one of the, as is discussed here, that can be one of the reasons, right, we have reliable new evidence that indicates that a crime occurred, so that's a basis in and of itself for saying we're going to extend the period of time. It would, and it would encourage, not to just, I can see a city now or a county, a prosecuting authority, if 15 years has passed, why keep that rape kit around? Just make room and toss it, right? Why keep the evidence around? Just toss it. So I think maybe I would be much more comfortable with the suggestion that A and B felonies, we say there should be no statute of limitations on those, but any lesser crime that, the legislature should take a look at what the appropriate statute of limitations should be. And I don't know how you decide 15 versus 20, who can say what that is. But having been involved in situations where claims have arisen that took place 20, 30, 40 years ago, people die, memories are shot, I'm faced with the dilemma defending companies that sold a product 50 years ago when nobody who was around it lives, right? And so and if that's a criminal situation that's made against you, you're going to have challenges in how you defend yourself, and that's why we have these limitation periods. So I would be much more comfortable, and I'm happy to make the motion to amend your motion to amend to eliminate it for A and B felonies, and should look at whether to extend it for other child sex crimes. That sends the legislature the message that with the most heinous, we think we need to extend it, but let's take a hard look at what we should do with the rest of them, with the understanding that you're right, our citizens get outraged when you say, we think he did it, but we can't do anything about it.
I don't have a problem with, I don't want you to amend to amend to amend. I don't have a problem withdrawing the motion if there, and you're certainly a more learned man in this area, so I certainly would yield to your thoughts on this, because you have to deal with both sides of it, where I only have to deal with one. Did you have what were you saying? Yeah. So I for the sake of discussion in this group, if the seconder will allow, I'll pull back the motion to listen to your motion and have discussion on it.
I agree with that. I'll pull back my second on your original motion so that we can further discuss and maybe have a new motion.
All right, thank you.
Okay. The motion is, to amend is withdrawn, and now I'll entertain any other motion concerning this issue.
So I think if you'll give me the floor to make a motion, yes, Mayor, it would be that it should say Tennessee should fully eliminate the statute of limitations for Class A and Class B felony child sex abuse crimes, and consider extending or eliminating the statute of limitations for other child sex abuse crimes.
Under that motion, I second it.
Okay, that's a motion to amend the report. Do we have discussion on the motion now? The motion to amend. Further discussion?
Mr. Chairman,
Yes.
that still leaves bullet number 2 in the report. Is that correct?
The motion wasn't.
Okay.
I thought we were eliminating bullet 2.
Okay,
That's
you'll
what-
have to make that part
I'm
of your
sorry.
motion
So let me-
if you do.
I apologize. Let me
No problem.
try to get this right. Bullet point 1 would be, as we discussed, we would eliminate bullet point 2. So there's no alternative. It's simply because I think bullet point 1 probably, in the second aspect of it, incorporates if they want to do something under B. So my motion would be we simply amend bullet point 1 and eliminate bullet point 2.
Mr. Chairman, my second stands.
Okay. You've heard the motion and the second to amend. Do we have further discussion on the motion? Yes, Mayor.
Thank you, Mr. Chairman. As we do that in the report, we still have, we talk about these 2 bullet points. We still have the report recommends that the state may want to consider extending or eliminating the statute of limitations on second-degree murder. That will still stay in the report, and also it will still stay in the report that we're going to try to correct a mistake that we had previously made. I'm fine with that. Thank you.
That's correct. Further discussion on the amendment? Yes.
Mr. Chairman, just for clarification, Mayor, you had mentioned that evidence came forth. You do not want to include that?
My motion would be for Class A and Class B, we just eliminate it. The lesser felonies, the legislature, I would take that language and look at it, which may be to incorporate some of that or some of the lesser ones. But for an A or B felony, I'm comfortable, as the motion indicates, with eliminating statute of limitations for those most serious felony classifications.
I agree. Thank you.
Okay, further discussion on the amendment? Okay, I think we're ready to vote. Everyone in favor of the amendment that the motion has been made to amend this report, please indicate so by saying aye.
Aye.
All opposed likewise. The amendment is passed. Now we're back on the report as amended. I'll entertain a motion to approve the report. So we have a second. Okay, we've got a motion second. Yes, Mayor.
Thank you, Chairman. I just had a question at the risk of being the new guy on the committee, on the commission. My question, having the earlier conversation about taxation, where it all has to do about revenue. My question about this report on page 15 and 16, where you mention the fiscal costs for prior legislation indicate extending or eliminating limitations would either be insignificant or relatively small, but in the full paragraph it says generally Tennessee Department of Corrections estimates a modest increase in their costs, and the Tennessee District Attorneys and Public Defenders typically estimate increased in costs since they think additional attorneys would be necessary. So my question, being a recovering legislator, everything that has a cost, whether it comes from this commission or any other, although it could be a fantastically effective and needed change, do you all offer funding mechanism ideas that this should be a part of the governor's budget, this should be a part of any other way? Because as good as it is, if there's not the funds to pay for it, I've seen many really good ideas not be able to be funded because of our legislative rules.
And
thank you, Mr. Chairman.
I may have to let Cliff answer that, but I will say that the information at the bottom of that paragraph, that's it from the prosecutors and the Department of Correction. That was the information that they provided to Fiscal Review. Fiscal Review, I guess, made a decision that it was still insignificant, despite what was provided to them by the prosecutors.
Okay. Further questions or comments? Hearing none, I think we're ready to vote. We have a proper motion and second made to approve the report as amended. All in favor of that motion, please indicate so by saying aye.
Aye.
All opposed likewise. Motion passes. Report's approved as amended. Now, do we have further business today? Hearing no further business without objection, we'll adjourn till 8:30 in the morning.
You may leave your material.
Yeah, you may leave your material if you'd like.